And Judge, the reason for this offer, if the court is inclined to follow it, just so you know, the motion was actually filed 10 days before she was set to expire out completely. So we're just trying to double back and address the addiction issue.
All right, Ms. Verdine, in cause number 22-40028, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 25th of 2023 for the third-degree felony offense of obstruction 26 DCCR 0210 and 0211. Ms. Riley entered pleas of guilty in each of those, which are theft of property with previous convictions. The agreement on all of these was for a cap of 15 months in the state jail prison. I've received the pre-sentence report. Have you both had an opportunity to review that report?
We have, Your Honor.
Yes, Your Honor, we have.
Any additions or corrections?
Not from the defense.
Nothing from the state, Your Honor.
All right, Mr. Rojas, you may proceed.
Thank you, Judge. I know it's a big ask, Judge, and it's not something that the court, I think, probably is leaning toward, but we're asking the court to consider probation in all these cases. Ms. Riley is 27 years old. She's got 2 young kids at home. As you can see from the PSI, most of her previous offenses are theft or some type of deception cases. And certainly she's old enough to know better. She should know better. I think if you look closer at her background, it's a situation where she never really had a chance to get any kind of direction in her life. She was placed in the CPS custody when she was 3 months old. I think she lived with her aunt until she was 14. I think all that time, or most of that time, her mother was in prison. And when her mother got out of prison, Ms. Riley went back to live with her mom. From 14 to 17, at 17, she ran away from home. And I think her father's in prison now. I don't know how long he's been in prison, but he's in prison now. I think the easy thing to do is to go ahead and send her to the state jail. Not only for the court, the easy thing for Ms. Riley would be to send her to the state jail, so that when she gets out, her slate is clean. She starts all over. I don't know that that's gonna. I think if that happens, Judge, she's probably gonna be back in the same place she's at, committing offenses, committing more thefts. What I'm asking the court to do is consider probation with possibly ISF, the cognitive track of ISF, so that she can get some direction. Hopefully, start learning how to make better decisions, and get her life onto the right track. And I think, do you want to say something to the judge?
Yes.
At the appropriate time, she wants to say something.
Go ahead.
No, I have had time to sit and think about my consequences. I wanted to I have talked to my aunt that I was staying with at first. She said that I could come back to stay with me and my 2 children. She's willing to help me try to get a GED and to get into the infirmary and the plant like the refinements. So
You need to look back. The NTRP case for me. How long she said? All right, Mr. Nichols.
Judge, I think the 15 months is appropriate in this case. Her misdemeanor history is incredibly extensive, lots of thefts, lots of probations that have been revoked. And if you follow the timeline, it's for committing thefts while on those probations, which is what she did here. Two new thefts, 6-7 months after being placed on probation for theft. So I think given her criminal history and continuing to commit crimes while on probation, I think 15 months state jail is appropriate.
Give me just a second. I want
To this case?
No, I'm wanting to know, and it's not really going to make a big difference, but you know, she said she's had time to sit and think. And what I wanted to know was how long she had to sit and think before she took the probation on the case she's on right now.
I can go back and look it up if you need it.
But so Miss Riley, you were on probation. You've had 1, 6, 7 probations. 7. You were given a probation for this felony, and 4 months later, you picked up 2 new theft cases. You've had every opportunity for whatever help it is that is out there. It's not like you've just taken time and not had opportunities with probation to help you. And so at this time in cause number 24 DC, excuse me. 24, DCCR 1778. I'm going to find that you entered your pleas of true freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of theft of property. Sentence you to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Clause number 26, DCCR 0210. Find that you pled guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of theft of property. Sentence you to a term of 15 months in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then finally, in clause number 26, DCCR 0211, find sufficient evidence to find you guilty of theft of property. Find you guilty of that offense, sentence you to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm handing you the trial court certifications in each of those cases that shows that these were agreements that I followed, so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. There's a real easy way for you to stop being incarcerated, and that's to stop stealing. You can't expect to keep doing the same thing and not have more harsh consequences. And so you need to understand that when you get out of state jail, if you do this again, it's going to get worse every single time. So if you want to be there for your kids and break the cycle, then that's going to be up to you to break that cycle. All right. Back with the bailiff. Charles Verdine.
Carlson, A.
Charleston Verdine. Charleston Renee Verdine.
You had Charles Verdine.
We've already met.
I have. This is okay. This is Charleston.
That all the birthdays.
Mm-hmm.
This one.
It's different. Welcome to the.
Yeah. Well, good morning, ma'am. Are you Charleston Verdine?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the motion?
She will, Your Honor.
And Judge, the reason for this offer, if the court is inclined to follow it, just so you know, the motion was actually filed 10 days before she was set to expire out completely. So we're just trying to double back and address the addiction issue.
All right, Ms. Verdine, in cause number 22-40028, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 25th of 2023 for the third-degree felony offense of obstruction or retaliation, and that was a 3-year deferred probation. Is that correct?
Yes, ma'am.
The motion alleges that you violated your probation. Is that 1 through 5?
It is, Your Honor.
Count 1 alleges that you provided a urine sample June 26th, October 15th, and November 17th of 2025 that tested positive for tetrahydrocannabinol. And is that true or not true?
Yes, ma'am. True.
That's marijuana.
Yes, ma'am. True.
Okay. Count 2 alleges that you failed to successfully complete the GED program as directed. Is that true or not true?
True.
Count 3 alleges that you failed to abstain from the use of any and all intoxicating substances, including alcohol, and that you tested positive for alcohol June 26th and October 15th of 2025. And is that true or not true?
True.
Count 4 alleges that you failed to submit to alcohol or drug screening October 14th of 2025. And is that true or not true?
True.
And then count 5 alleges that you failed to successfully complete the moral recognition therapy program. Is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 5 freely and voluntarily?
Yes, ma'am.
And did you plead true to those because they're actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement is for me to continue your probation and extend it for 2 years, Order that you enter and successfully complete the JCDI program, which would also include a drug patch. Is that your understanding?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted any evidence that Ms. Verdine is not competent.
Oh, yeah.
So I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I do want to get an updated report. So we need to figure out between now and then what I can do between now and then. I just want to make sure that probation also agrees that that's all of the treatment and everything that's necessary. I'm willing to set a bond, and she's on probation. She can go ahead and start those programs, but I want to make sure, I think, that we're covering everything, if that makes sense.
Judge, she's been incarcerated for a while. Would the court consider a PR bond?
Yeah. So, okay. So what I'm going to do, Ms. Verdine, is I'm going to reset your case for sentencing. I'm not going to sentence you and extend it today. We're going to do that later. But I am going to reduce or set a bond for you in the amount of $1,000, but make that a personal bond, which means you don't have to pay any money. You're just going to get out of jail.
Yes, ma'am.
You're still on this probation. You're required to do everything, including starting that JCDI program. You have to have a drug patch on within 24 hours of your release from custody.
Yes, ma'am.
If you don't do that, I don't have to go along with this agreement when you come back. If you test positive between now and then, you're going to be right back in jail. Do you understand?
Yes, ma'am.
You can talk to your probation officer about where to get that drug patch. They'll help you with that, and then we'll see you back at sentencing. Okay.
Yes, ma'am.
All right. You can go back with the bailiff.
I have a question.
Hang on just a second.
Is the drug patch right now just gonna be a condition of a bond? Or,
It's going to be both.
okay,
It needs to be a condition of probation and bond. Yes, ma'am.
I forgot what I was saying.
Sorry.
So I forgot.
Okay. If you think of it, Mr. Rojas will be around. You can tell one of the bailiffs. All right. You can go back with the bailiff.
Personally, I think today's hearing showed that every defendant is given the opportunity to change, but what happens next depends on the choices they make. One defendant had already received multiple chances through probation, yet continued committing the same offenses, leaving the judge with little choice but to impose a prison sentence. Another admitted violating probation, but because she accepted responsibility and agreed to treatment, the court was willing to give her one final opportunity. That contrast says everything. The justice system can offer second chances, but those chances don't last forever. At some point, accountability has to take over. Let me know what you think about these decisions in the comments below. And if you enjoyed this courtroom breakdown, don't forget to like, subscribe, and I'll see you in the next video.